As criminal defense attorneys, we spend a lot of time talking with our clients about no contact orders. What are they? Why are they issued? What can you do about them? And I want to talk a little bit about that today. No contact order is a formal order entered by a criminal law judge, generally at an arraignment, at the initial stages of a criminal case where somebody is formally told about the case, prohibiting somebody from either having contact with a person, a witness, or a location, and or staying a certain distance away from that person, witness, or location. In general, that is what a no contact order is. And they are sacrosanct. They are sacred in the criminal law system. And from a criminal defense attorney, they're sacred because it's a judge's personal decision, his order, telling our client to behave in a certain way. And violations of no contact orders, aside from bringing a new criminal charge and a basis of putting somebody back in jail because they won't abide by the judge's advice or the judge's order in this case, it indicates a lack of respect for the system and a lack of respect to the judge. And though judges are people and they attempt to be objective, it's hard for them to not get a little bit subjective and take it a little personal when somebody won't listen to them. So it becomes really important that no contact orders are abided by, and it also is really important that as defense attorneys we anticipate what impact they're going to have in our clients' lives. So for example, here's some common issues that happens. A judge enters a no contact order for a victim, and somebody has to stay 500 feet away from them, and that victim happens to go to the same college as our client. And so they may not share a common class, but my client is suddenly terrified about violating the no contact order, which happens to have a 500-foot restriction that wasn't addressed initially at arraignment because we weren't there and we hadn't talked to our client in advance. We deal with issues where no contact orders prohibit somebody from talking to their spouse, and the spouse wants to, and the two people believe that they want to work through a criminal charge or an event, an isolated incident where the police were called and a case has been started, but they want to work through it with counseling or they want to work through it through other means, and the judge's order prevents that from happening. Or two people don't want to work through it, but they have children in common. How do they exchange children when there's a prohibition of contact and a distance restriction from the house, 500 feet? How do they make arrangements to exchange children? These are very real issues. These are situations we have dealt with repeatedly in the past for our clients. And so you can see how a no contact order can start having impact on somebody's life. It's important with that in mind, to anticipate that a no contact order will be entered and take steps to craft a solution that is sensible and rational and supported to present to a judge as a counter argument to what a prosecuting attorney will say, which is, as generally as a policy, we need a no contact order involving any victim or any witness involved in a case, and we need a distance restriction. We don't really care about the details. And so it becomes the burden of the criminal defense attorney to have taken the time to talk to their client, understand intimately what's going on, anticipate the possibility of one of these, and propose solutions to a judge that are sensible. These are things that are, as a generality, it's really good to get in early on in a no contact order while they're being issued and address these issues. They can be addressed in hindsight, they can be addressed later on in the case, but you're sort of fighting uphill. You're trying to change something that's already been ordered. And so changing something that's already been ordered, and from my perspective, kind of set in stone a bit, becomes more difficult than when things are loose and a judge is open to argument and suggestion. It's important to realize that if you violate these no contact orders, even with the best of intentions, that it gives an enormous amount of power to the other person who you're violating it with, even if it's done in secret. And we have had cases where people believe that they're going to work through a disagreement. Two people are married 20 years. They think they're going to work through a disagreement. It's the first time there's ever been a criminal event. and my client thinks things will work through and starts contacting the other party, and things don't end up working through. I have had situations where the other party ends up reporting them as in violation of the no contact order. I have had it become a factor in family law cases. I've had family law lawyers bring up that they will do this reporting, and though this is sort of the dirty underbelly of no contact orders, it's another reason why people who have a lot of experience and wisdom and have dealt with thousands of criminal law cases should be kind of giving you direction that you listen to as you navigate these kinds of waters.